know, we are all committed to responding in a timely way to public records. Our office bends over backwards to expedite production of documents that we can, and we believe strongly in the idea of transparent government. This question, though, about whether all privileged documents from the city attorney's office that go beyond just advising us as the law and provide strategic advice and give us best judgment about risk in cases that are still ongoing seems to me to present a significant challenge. And I was persuaded when Harry briefed me that we should do both. We should raise this as a question for the legislature to ponder, but we should also seek an appellate ruling so that we have clarity about where to go next.
I hear you. I guess the situation in which an issue is still ongoing 25 years later is obviously rare. The Superfund, as you argue, is one of those instances. So your understanding is the law makes no distinction between legal issues that are still ongoing versus just history that for some reason somebody wouldn't want to disclose.
Harry, is that right?
The records that we are...
The statute doesn't make that distinction, that is correct.
I believe the records Mr. Bartlett wants are connected with the reservoirs, which I'm not sure we're entirely done with yet either.
Right.
So
right.
Mr. Walters obviously
There's a
has
couple
something
of
to add here.
instances, yeah.
So Ben Walters with the City Attorney's Office. Part of the dilemma here is that Jennifer Johnston, who worked on the public records request response, is not in the office today. And so Harry came in to help with this matter, but I know a little bit more about it having conferred with Jennifer. The dilemma that we face is that there is a very quick turnaround time for filing an appeal. We have to give notice to the requesting party and the district attorney of our intent to file an appeal within 7 days of the order being issued. And so we had to bring this before you on an expedited basis. There was a question about is there any interpretation out there that exists for a different outcome. And I would just note that Jennifer pointed out to me that the State Attorney General's office is actually not of one mind on how this provision, the waiver provision, should be interpreted. They've issued conflicting opinions, arriving at one conclusion many years ago that determined that the exemption, the waiver exemption, applied across the board, and then subsequently, more recently, within I think the last decade, issued an opinion in which they concluded the opposite, that the waiver provision was a general provision and did not control in specific circumstances, which is a different canon of statutory construction. So there is some disagreement out there among the folks who have been asked to interpret this. So there is an opening there for our office to seek some clarification from the judiciary and get a determination as to which one of these analyses would control.
Mayor, I have a suggestion, because this is a obviously complicated area. If we don't provide notice of intent to appeal, we can't appeal, so the doors are closed.
Right, I understand.
And we have, from time to time, protected our right to appeal issues so that we can later decide not to, or to proceed, or on what basis. So that's the first question, and that seems to be time sensitive. The second has to do with the scope of Mr. Bartlett's document request. I think it'd be entirely appropriate for us to ask Jennifer Johnson to brief a council member about the scope of that request and to see whether any of those things can be resolved informally, because we would all prefer to have non-privileged, non-sensitive documents produced for obvious reasons. And the third is that we could say that before, since notice of appeal is different from appealing, we could say that before city attorney files any appeal, we have a follow-up discussion about the utility of that versus legislative relief. So that today we're just limited to getting approval to put a marker down for a notice of appeal, which we would otherwise lose. And then when Jennifer is back in the saddle, we can talk about a range of options, including potentially not appealing.
Let me just clarify. Excuse me, I'm a little under the weather, so I'm sucking on a lozenge here. I apologize. the statute requires that we give notice of our intent within 7 days of the district attorney's decision, and that we file the action within 7 days after that, or else we're required to pay the requester's attorney's fees whether we win or lose. So you're basically, what we're trying to do is save you the expense of having to pay Mr. Bartlett if he hires an attorney if we win the case. So I just want to be clear on what's at stake with the 7 and 7.
Again, I propose a dual track where we make every effort to produce all the documents that don't fall within any concern we have, and we get a clarifying ruling about when does the public records law trump in any way attorney-client privileges in ongoing cases where, frankly, producing those documents puts us at a disadvantage with other parties that would like nothing more than to know our legal strategy and use it against them.
Yeah, those distinctions do make a difference for me. I find that more credible than my first view of this. So that's helpful. Thank you. Further questions for staff? Thank you both.
So we're approving the notice of intent to appeal, but we're also basically.
You're authorizing us to
Filing
go
the
forward.
appeal.
That's correct. You're authorizing us to go forward.
Right, okay.
All right, let's see if there's testimony on this item, and then we'll take action.